Kaleshwara temple were erected on the site where the Madras High Court is presently located, and therefore this building has been blessed by gods. It means to say that, I quote, on the site that the temple of God was located, that the temple of justice came to be built. The cost of the building, no, you won't believe, the cost of the High Court building at that time was well near rupees 13 lakhs. 1-3. The building of this age and character is a constant source of inspiration for both the bench and the bar and to the litigant public. In the words of the then Chief Justice, Sir Arthur Collins of this prestigious High Court, when the key of the building was handed over to him by the then Governor, His Excellency Lord Wenlock, concluded with the words, I quote, I have pleasure in handing you the key as a token that the building has been entrusted to your hands by the government in full confidence that the administration of justice will be carried on with the ability and integrity that has always marked the Madras High Court. To you, my Lord, and to the other gentlemen who hold with you the high position of judges of the High Court, and to those gentlemen who occupy themselves in the honourable and learned profession of law, in all your hands the administration of justice will be safely left, and we may look forward for many years to come with a full knowledge and full satisfaction that the best years of your lives will be devoted to carrying on one of the noblest of works, the uninterrupted administration of justice, unquote. When I was the chairman of the Law Commission of India, I received a letter from the Committee of Parliament on Official Language made in its report at serial number 16.8D and 8E of the Department of Official Language, Government of India, as to whether Hindi can be made as a language of practice in the High Courts and Supreme Court. As chairman of the Law Commission, I addressed letters to all the retired Chief Justices of the Supreme Court, judges of the Supreme Court, senior advocates from different parts of the country, and also to various bar associations in different states for eliciting their views. In response to my letter, the Law Commission received overwhelming response. The Law Commission has sent a detailed report to the Law Ministry. In this report, the Law Commission examined the feasibility of introduction of Hindi as compulsory language in the Supreme Court and the High Court. The Law Commission has also taken into account the views expressed by the legal fraternity in this regard and concluded that, I quote, the Commission recommended that at any rate, no language should be thrust upon the judges of the higher judiciary, and they should be left free to deliver their judgments in the language they prefer. Language is not merely a vehicle of thought and expression, but for judges at the higher level, it is an integral part of their decision-making process. Judges have to hear and understand the submissions of both the sides, apply the law to adjust equities. Arguments are generally made in higher courts in English, and the best literature under the Indian legal system is primarily based on English and American textbooks and case laws. Thus, judges at the higher level should be left free to evolve their own pattern of delivering judgments. It may, however, I also added in the report, it may, however, be noted that insofar as the legislative drafting is concerned, every legislation, although authoritatively enacted in English, may have a Hindi authoritative translation along with the same at the central level. Same analogy may be applied even in respect of executive actions at the central level, but as submitted above, the higher judiciary should not be subjected to any kind of even persuasive change in the present social context. The same principle may not apply insofar as introduction of Tamil as an additional court language is concerned. It can definitely be introduced in a phased manner. Before introducing Tamil as a court language, one must impart training to all concerned to argue the matter before the court in Tamil and write judgments in Tamil. Only after granting and gaining enough experience in this field, this can be slowly introduced in courts, and the government must immediately constitute a committee and also form a department and appoint required number of retired judicial officers who are well versed both in English and Tamil, so that their services can be effectively utilized to translate all the statutes, acts, rules, and regulations from English to Tamil. In the beginning, the lawyers and judges respectively may find it difficult to argue and hear the cases, and over a period of time, the judges can do well and write judgments in Tamil language. The government must set up immediately a state law commission and a language department. This, the very same thing I have said in another meeting where another book was released. I said that about 2 years before. So far nothing has been done. Under Article 348, Clause 2, the governor of the state may authorize use of any other languages, either for the official purpose of the state or in proceedings in the concerned High Court, subject to the previous consent of the President of India. It is rightly said that the reading makes full man, conference a rich man, and writing an executive man. A man may as well expect to grow stronger by always eating as wiser by always reading. I therefore expect that this book and the journal Satta Kadir, which cover legal issues of far-reaching importance, touching the subjects of common man and his expressions, will be a useful addition in all the libraries and courts. The law is the true embodiment of everything that is excellent, since the common man is ignorant about its knowledge and application. The magazine and the book, which is to be released by our Honourable Law Minister, will fill that void. I wish Satta Kadir and its editor, Dr. Sampath, in particular, all well to reach the newer heights in the years ahead. Thank you all.